Good afternoon, everyone. It gives me a very great pleasure to introduce our speaker today. This is Dr. Andriani Kalintiri, who is currently a senior lecturer at King's College London, which, as you know, is a world-leading center in the study of competition law. I'm particularly happy because Andriani was an LLM student, outstanding LLM student of this faculty, and then went on to do a PhD under the direction of Professor Takis Tridimas. And then she spent a period of a research fellowship at the London School of Economics, was a lecturer for a year at City University before taking up her position in King's College London. So following from the very interesting competition theme seminar that we had last week from Professor Ackerman, we have another competition theme seminar where she's going to talk about the resilience of antitrust. And without any more delay, I just leave the floor to Dr. Kalintiri. Thank you so much.
Thank you. So good afternoon, everyone, and thank you so much to Albertina for the kind invitation and for the very kind introduction. I'm very excited to be back in Cambridge. So as Albertina mentioned, I did my master here in 2010. I actually had seminars in this very same room. I took EU trade law, and I remember it was in this very same room. And some of my teachers are in this room, Albertina, okay, Catherine in the back. So I'm very grateful for the education I received here and the commitment and the kindness of the teachers. So I'm very delighted to be back today to talk about a recent paper of mine. We discussed this a seemingly simple question, and that is whether EU antitrust law is resilient in the face of change. And this is a question that has received prominence in recent years amid the many changes, crises, disruptions we have experienced, such as COVID, climate change, digitalisation. And the underlying concern behind this question is that EU antitrust law may not be fit for purpose, may not be well-suited, capable to deal with change, crises, especially in complex and uncertain and fast-paced environments. However, when I started thinking about this question, I quickly realized that it's not clear what we mean by legal resilience. What does it mean for a legal system to be resilient? And it's not clear what makes a legal system resilient more or less so. So what I'm trying to do in this paper is two things. First, to develop a conceptual and analytical framework for understanding and assessing the resilience of a legal system. And my focus is on liability regimes. What I mean by that is when you have a set of rules that prohibit certain behaviors and impose liability for non-compliance. And in the specific context of administrative enforcement. So when you have an administrative authority that acts as the first instance decision maker, and then if decisions are subject to judicial review. So that's the first thing I'm trying to do in the paper. And then I apply that framework to EU antitrust law, Articles 101 and Article 102, in order to evaluate its resilience in a hopefully methodologically rigorous manner. And also offer some suggestions, some recommendations based on the discussion. So, what do we talk about when we talk about legal resilience? Essentially, what we talk about is how the law responds to change. And the reason why we care about this is because the substantive and the procedural rules in place are grounded in certain assumptions about the context, for instance, within which the rules are applied, and they also reflect a certain balance of harms, risks, powers. And once the rules are adopted, it is deemed that they are effective, and it is deemed that they will remain effective. However, the world changes, of course. So there are shifts, there are developments, there are new problems, and these may be more or less complex. So when this happens, the question, of course, is how the law can react to these changes. And the law may react in three ways. One option is to remain the same. That's what I call absorption. So the law absorbs the change, and that will be the case when the underlying assumptions are still deemed valid and the underlying balance of harms, risks, powers is still deemed appropriate. And therefore, the rules are deemed to continue to be effective. So we don't have to change anything. A second option is for the law to adapt. And in the paper, I explained that this might be the case where the assumptions are still valid, the balance of powers, risks, harms is still deemed appropriate, but the rules are not as effective because of the change and therefore the need to be adapted. And the third option is for the law to transform, and that will be the case when the underlying assumptions are no longer deemed valid, the balance of powers, harms, risks is no longer deemed appropriate, and therefore the rules are not effective and the law needs to change. I think it seems to me also drawing on the way the notion of resilience has been conceptualized in other disciplines, that it makes sense to define legal resilience as the ability of a legal system to absorb, adapt, and transform in response to change. And I think this definition has added value in the sense that it provides a more nuanced account of how the law responds to change. When we think about that, we tend to think about adaptation, right? So we tend to think about legal adaptation. But I think the legal resilience framework reveals that absorption is also a possible response, and oftentimes it may be an appropriate response as well. And I think this three-dimensional conceptualization of resilience also reveals that there is a difference between legal adaptation and legal transformation. And this difference is not the question, a matter of how the law changes, if it changes through the adoption of legislation or the adoption of soft law or new case law. It's not a matter of degree, how much of the law changes, but it is a matter of kind, what changes. And what changes in the case of transformation, in my view, or at least what I'm arguing in the paper, is the underlying assumptions and the underlying balance of powers, harms, and risks. Okay. Now, if we accept this definition, still the question remains, how are we going to assess legal resilience? So how are we going to determine whether a legal system is resilient or not? And in the paper, I'm arguing that we need to consider at least two things. We need to consider, first of all, the extent to which the design features of the legal system allow decision makers to make absorption, adaptation, and transformation choices as needed. So that's the first thing. And then we need to also look at the extent to which the resilient choices that decision makers actually make are justifiable. Okay? So going back to the first issue, the design features, it seems to me that we need to look in particular at these two things. First of all, the goals of the law, the design of the substantive norms, and any applicable evidence rules. And I'm going to explain briefly why. So as is obviously the case, when you have goals with, let's say, a degree of give, then this may allow you to accommodate multiple or more interpretations, more possible applications of the legal rules in more context, so to say. Likewise, when you have open concepts or when you have standards as opposed to rules, again, this may allow more easily for the integration of context-specific circumstances into the legal analysis. And this may better accommodate complexity and uncertainty too. It may allow you to take into account the particularities of the specific case, better at least so. Likewise, depending on the calibration of the liability rules and the applicable evidence rules, this may also impact the extent to which the legal system tolerates uncertainty and complexity. So, for example, if liability is conditional on showing, let's say, likely harm, then intervention is going to be much more difficult in situations of uncertainty and complexity compared to a rule that merely requires plausible harm. Or depending on the applicable standard of proof, again, intervention may be more easy or more difficult. So if you have to show more likely than not that something is the case, then that makes it easier for you to intervene compared to a standard proof, which is, for instance, beyond any reasonable doubt. So I'm saying we need to look at all these things first. And we also need to consider whether there is a range of diverse information gathering, stakeholder engagement, and intervention mechanisms. And again, I think for obvious reasons, when decision makers are faced with complexity, uncertainty, change in general of any kind, they need to be able to identify, locate relevant information and evidence. They need to be able to evaluate what this information means for the existing assumptions and balance of harms, powers, risk. They need to be able to develop new consensus positions and identify appropriate courses of action. And they need to be able to actually take action. So I think these features of a legal system can tell us a bit more how resilient the legal system is or not. As I said, however, and just to note that depending on how these features are calibrated, one may identify what I call in the paper a resilience capability or a resilience vulnerability in the system. Now, beyond the design features of the system, we need to also look at the choices that decision makers actually make. And the question, as I have framed it in the paper, is whether these choices are justifiable. Now, what makes those choices justifiable? That's a very difficult question, but what I'm trying to say is that we need to consider at least whether they make sense, so to say, in simple words, given the nature of the problem at hand. And we need to consider any implications that they may have for legal certainty, coherence, and legitimacy. And let me briefly say a few words on these things. So, for example, when it comes to legal certainty, instances of response to change through the use of informal ad hoc tools or through the use of soft law, which deviates from existing doctrine or addresses novel issues that have not been considered by the courts yet. In this case, the line between permissible and non-permissible behavior may become further blurred. From a coherence perspective, the risk may arise when the resilience choices that decision makers make result in the parallel operation of substantive and procedural rules that do not harmoniously fit together. And as regards legitimacy, it seems to me that there may be an issue there when, in their efforts to respond to change, decision makers end up using the tool in a way that exceeds its function. And when it comes to liability regimes, it seems to me that their operation rests on two assumptions. We assume that we know enough about the problem, and we assume that the imposition of liability is the best solution to the problem. And we also assume that societal harm is going to be prevented or deterred through adequate public and or private enforcement. And when these assumptions do not hold true for whatever reason, then using the tool to tackle the problem may not be legitimate, and other tools, regulation, for example, may be a more appropriate response, a more legitimate response. So, what does this all mean for EU antitrust law? So what I've tried to do in the paper is I've tried to apply this framework to Article 101 and 102. And I first look at the design features of EU antitrust law. And I think the picture is mixed, but there is definitely cause for optimism in the sense that there are many features of the legal system in place that allow decision makers to make absorption, adaptation, transformation choices and allow them to deal with changes when they're faced with epistemic developments and new problems. So what is good about the system? When we look at the goal, the substantive norms, and the evidence rules, I'm not going to spend too much time because I assume you're already familiar, most of you, with most of these issues. But basically, it's quite clear that the normative scope of 101 and 102 is quite malleable, quite flexible. People don't agree on what are the goals of competition law. There's, of course, a huge debate about that. But I think we can agree that the goal, even if we were to say it's consumer welfare, it can be interpreted in a flexible way as including effects not just on prices, but also choice, quality, innovation, and as including both direct and indirect harm, as the courts have confirmed. Another resilience capability of the system is, of course, the open texture of Articles 101 and 102. The letter is so broad that it allows for the application of the rules in various circumstances, and it is no coincidence that the letter has remained the same ever since these provisions were adopted, even though their actual application has evolved. Another important aspect, I think, of the legal system is the requirement for contextual analysis. Competition authorities, including the European Commission, they need to always consider the context, even in the case of by-object infringements, as we know from the case law. And I think that's quite important because it offers what I call in the paper a methodological gateway for kind of integrating contextual considerations and taking into account the particularities of different markets and sectors in the analysis, and in this way also tempering the horizontality of the rules, the fact that you have rules that apply across the board. Another important feature is that you don't need actual harm to intervene. That's quite clear from the case law, and that means that you can apply the rules in a precautionary manner, meaning that you don't have to wait until harm has materialized. The reliance on economics is also a resilience capability in the sense that it allows for the integration of epistemic developments in economics in the application of the competition rules. And when we look at the available information gathering, stakeholder engagement, and intervention mechanisms, there's really a lot to praise. I'm not going to go into any detail, but just to say the Commission and national authorities have the power, of course, to collect evidence, request information, conduct inspections. There are other mechanisms and policies that allow for the location of relevant evidence and knowledge, such as the leniency policy, cartel settlements, the fact that consumers or rivals may submit complaints formally or informally, the fact that they may submit their views in the context of, for instance, the market testing of remedies, the fact that the Commission may publish soft law documents following public consultation, and that allows more generally for the integration of contemporary knowledge and the development of consensus positions in EU antitrust law. And in terms of intervention, the power to accept commitments, to impose interim measures, to impose remedies, proactive and reactive, to adopt findings of inapplicability. So there's really a lot in the system that strengthens its resilience. So that's the good side of things. Now, how about what is bad? I think when one looks at the system a bit more closely, it becomes apparent that there are some resilience vulnerabilities too. And when we look at the gold substantive norms and evidence rules, there are certain things that kind of stand out. The first is that even though the goals of EU antitrust law are flexible, depending on how you define them, there remains still quite a lot of uncertainty and even disagreement about the relevance of non-economic aims or non-economic considerations in antitrust analysis. But when you have an ever-complex world where spheres of life and activities become even more interconnected, sometimes you may end up with harms that slip through the cracks of the law. And I'm going to give, I was trying to think of an example, and I think the best or perhaps a helpful example might be the use of algorithms for pricing, ranking, filtering purposes, targeting purposes. And sometimes the use of these algorithms may lead to higher prices for female products or lower quality for female services, or fewer opportunities for Black workers. And there is actually evidence, empirical evidence of these things happening. Now, these kind of harms They're not really caught at the moment by the competition rules, but I think on a systemic level, once they are accumulated, they may have some competition relevance. And at the moment, the legal system just doesn't address these kind of harms. Okay, now the second vulnerability is that EU antitrust law, based on current doctrine, or at least how I understand it, generally requires a high degree of knowledge and understanding about the nature of the harm and its impact. And this may be inferred in the case of, say, by-object infringements, or it may need to be established on a case-by-case basis, subject to a high standard of proof firm conviction. So the EU courts have explained in case law that the Commission needs to produce sufficiently precise, clear, consistent evidence to support the firm conviction that an infringement has taken place. And I think this may be difficult to do when you have complex problems characterized by uncertainty and lack of consensus in terms of what is the problem or what causes the problem or what is the impact, or also in the case of risks that may be high impact but low probability. Now, another point is that EU antitrust analysis at the moment focuses on distinct harmful acts, but it seems to me that sometimes harm may be the cumulative result of multiple acts by the same undertaking that may not be as harmful or harmful on their own, or it may be the cumulative result of multiple acts by multiple undertakings, each one on their own may not be legal. And at the moment, I think the legal system cannot adequately deal with these kind of harms. Of course, to apply the competition rules and find a violation, the Commission also needs to show a causal link between the act and the outcome, so the conduct and the harmful outcome. This is framed generally in competition law as the counterfactual analysis. You need to compare the situation before with the conduct and without the conduct. But in circumstances characterized by uncertainty and complexity, the causal link may not be linear, it may not be easily traceable, and in this case, applying the rules becomes more difficult. And then as regards the relevance of economics, economics can be, as I said, a resilience capability, but it's also a double-edged sword in the sense that once economic assumptions, concept theories turn into legal assumption, concept theories, tests, and so on, it can be difficult to change them. And I think we are seeing that with the more economic approach and the criticisms against the more economic approach, to the extent that its neoclassical economic foundations are deemed illustrated to describe competition in complex context, like in the digital sphere. But we already have legal concepts inspired from that, so we focus on relevant markets, whereas perhaps the focus should be on ecosystems, or we focus on dominance as power over prices, whereas we need to think of power in more complicated or richer ways, like gatekeeper power to set the rules of the game. And neoclassical economics rely on this presumption of rationality, but we know that, of course, agents are biased, including consumers. And when we look at the procedural framework, the available information gathering, stakeholder engagement, and intervention mechanism, what we have is good, but it's not perfect. We know, of course, that antitrust investigations are complex and take a lot of time. The Commission may gather relevant information formally or informally, but it doesn't mean that this information is necessarily helpful or objective or representative of all viewpoints. And some commentators have pointed out the risks of lobbying in EU competition policy, and also some obstacles perhaps to effective citizen participation. The available intervention mechanisms are also subject to constraints. So yes, the Commission may in theory adopt interim measures, but to adopt interim measures, you have to show a prima facie violation of 101 or 102, and this will be nearly impossible to do in circumstances of novel infringements, uncertainty, complexity. When it comes to commitments, yes, you can impose commitments, but the parties need to agree. So it's a voluntary mechanism. And when it comes to remedies, again, yes, the Commission has the power to impose remedies, and these remedies may also be quite far-reaching, but they are not. This power is not limitless, and it's not invariably effective, I would say, either. Especially in situations where the result is more, the harm is more the result of a harmful strategy rather than any given act. Or whether it is the cumulative result of multiple actors' behavior that lies beyond the infringer's unilateral control. And in the digital sphere, we can think, for instance, of how we users react to choice screens, how we react to privacy policies, and so on. And just to say that the Commission recently published the results of its evaluation of Regulation 1/2003 and Regulation 773, and it identified areas for improvement, especially as regards aspects of its investigative powers and as regards the efficiency of some of its procedures. So when we think of the design features of EU antitrust law, I would say the picture is mixed, right? So there are some things that are good, other things less so. Now, how about the resilience choices that the Commission and the courts have made in response to change and new problems? And in the paper, I look at 3 examples, COVID, climate change, and digitalisation. And I explain how the response was different each time. And I'm trying to kind of consider whether it was justifiable, given, first of all, the nature of the problem. So starting with COVID, I think mainly the response was one of absorption, right? So the legal framework didn't change. The Commission at the time issued guidance and some comfort letters for the first time ever since modernization, just to alleviate concerns. And they said that competition law applies as usual. But what they did was they changed some aspects of the notice on informal guidance to make it easier to provide informal guidance in the future. So they introduced a new criterion saying that I'm going to take into account the relevance of the agreement for my priorities and the union's interests. And the criterion of novel or unresolved question was expanded to include questions that in relation to which there is no sufficient clarity. And in the revised horizontal agreement guidelines, they also included references to market and supply chain resilience. And they've said these may be taken into account as efficiency gains in the future. So it seemed to me that the response to COVID was mostly one of absorption and adaptation, and reasonably so, I would say, given the nature of the problem. Now, when I look at climate change, I think the response was clearly one of adaptation. Again, there has been a lot of debate as to whether sustainability, environmental protection considerations must be integrated in antitrust analysis, and how so, for instance, as independent goals or as aspects of consumer welfare. And ultimately, what the Commission did was to include a chapter on sustainability agreements in the horizontal agreements guidelines. And I think the chapter doesn't fundamentally change the assumptions under which competition law is based. It doesn't fundamentally change the balance of powers, harms, risks. But what it does is it introduces various tricks. For instance, it introduces the notion of collective benefits in order to ensure that the framework will remain effective. Now, when we look at digitalization, I think the picture is different. I think it's maybe a little bit too soon to tell, and the dust hasn't settled yet, but it seems to me that there are signs there of transformation. So when we look at recent decisional practice, case law, and policy developments, I think we're seeing a move towards different assumptions about the context within which the competition rules are applied, and a move away from the classical economics. So, for example, market definition does remain an important part of antitrust analysis. However, we see references now to interconnected market complementary markets, and in Google Android, the general court went as far as explicitly referring to digital ecosystems. We also see new relevant factors, not as new anymore, for assessing market power and assessing harm, network effects, access to data, need for significant upfront investment. And the courts have said that, in digital markets, in the digital context, other aspects of competition may be more important compared to traditional, as the court put it, aspects of competition. So we may care more about access to data, privacy, rather than prices or market shares. And the Commission and the court have, of course, recognized the relevance of consumer biases, and they've taken these biases into account when they consider the impact of market practices on competition dynamics. And we have, of course, Microsoft, Google Shopping, Google Android, and so on. So I think we see some changes that are not reflective just of adaptation, but more of a transformation. And when we consider not the assumption, but the balance of harms, risks, powers in this new setting, again, I think we see some signs of transformation. I think considerations such as fairness, equality of opportunity play more of a role in competition analysis and in the understanding of what is competition on the merits. We also see some references to non-economic aims, for instance, in Google Android. The courts have defined abuse as conduct that harms not just as efficient rivals, but also impedes potentially competing undertakings at an earlier stage from entering the market. The threshold of harm for intervention is identified as capability to foreclose, whatever that means. Whereas in previous case law, we see references to the need to show probable effects or likely effects, which one might say are more demanding thresholds of harm. And also, in more recent cases, we see references not just to the firm conviction that the Commission needs to establish, but more broadly to the need to provide specific tangible points of analysis and evidence. And these novelties, some of them are already reflected in the amended enforcement priorities guidance and the draft 1 or 2 guidelines that the Commission published in August. And I think these changes have had these resilient choices. They make sense given the nature of the problem, but they have had implications for legal certainty, coherence, and legitimacy that have not been sufficiently appreciated. When it comes to legal certainty, I think the key question is what is to become of the more economic approach. So the more economic approach was meant to provide an expertise-based framework to rationalize and legitimize competition enforcement, but I think its promise never fully matched its reality. And also what the more economic approach actually entails, it seems to me to some extent it is in the eye of the beholder. So we care about effects on competition and consumers, but we know the courts have never unequivocally endorsed consumer welfare as the goal. And also, what is the applicable threshold of effects? It's not entirely clear. How these effects may be established, again, there is, I think, some uncertainty around that. I think also the additional demands on enforcers were underestimated. It may not be clear, perhaps, what the more economic approach exactly entails, but I think it's clear that it demands more from enforcers and perhaps different from enforcers as well. And as I said already, its neoclassical underpinnings may not fare well in explaining competition dynamics in complex contexts and in the digital sphere. So I think the draft Article 1 or 2 guidelines make some efforts to rectify some of these shortcomings, and among others, they introduce some presumptions of harm to make enforcement more certain and more administrable and more efficient. But I think they do not necessarily go as far, and I'll be happy to discuss this further later. Now, when we think of the implication for coherence, I think the issue, as I'm seeing it, is that we have 2 different versions of competition law in parallel operation. We have the traditional competition law that still applies, is still relevant in relation, say, to cartel distribution agreements, and the framework is still good enough. And then we have the digital competition law, which is a very different kind of beast. So my question is more, can these two versions operate in parallel without the coherence of the legal system becoming fundamentally undermined? And when it comes to legitimacy, I think competition law rests on certain assumptions. As I said, I think it assumes that you have a market that is intrinsically capable of being competitive, at least to some extent, and that the competitiveness of the market can be preserved through the imposition of appropriate negative or positive obligations. And it also assumes that we have a minimum degree of knowledge and understanding about the conduct and its impact on competition and about the appropriate solution. And it is thanks to that minimum degree of knowledge and understanding, we are able accurately to identify legal behavior, and we are able to devise effective remedies. Now, when these assumptions are not true in any given context, then perhaps using competition law as a tool for tackling problems may go beyond what competition law can do as a tool, and in that case, its legitimacy may be affected. And it may affect both the input legitimacy when competition authorities are perceived to act beyond their mandate, throughput legitimacy when, decision-making gives the impression that we're trying to stretch the boundaries of the law to bring more practices within the prohibitions, and also perhaps more importantly in this context, output legitimacy when the remedies cannot be effective. And I think we've seen that with Google Shopping and Google Android. The remedies, after many years of investigation and enforcement, they just haven't been effective. And in this case, I think that regulations such as the Digital Markets Act, the DMA, it seems to me is a more legitimate response to the problem. Okay, just to perhaps wrap up this analysis. Where does this leave us? I think with certain lessons, general and specific. I think going back to the lens of legal resilience, it seems to me that this notion of legal resilience has significant descriptive and explanatory value in the sense that it can allow us better to map how antitrust law or the law in general responds to change, and it can allow us to better differentiate between responses to change and have a more holistic visualization of how the discipline evolves, but also it sheds more light on aspects of the system, I guess, that, may strengthen resilience, but also weaken resilience. And I think when enforcers are faced with change, this framework may serve as a guide to better diagnose the problem, see what is possible given existing design features, what may be the implications of any given resilience choice, and, better to or more easily to spot any blind spots and take effective action. Now, in more concrete terms, I think the conclusion for EU antitrust law is that clearly it's not unable to deal with change. So if anyone is worried about that, I think these fears are unfounded. But at the same time, I think the analysis reveals that it may struggle indeed to cope with change in circumstances of uncertainty and complexity for three reasons that I already explained, but I'm going to repeat briefly. It generally requires a high degree of knowledge and understanding that may be missing yet, at least, while change happens. Also that the more economic approach has had certain shortcomings, it has increased demand on enforcers, and it has tied to some extent the application of the competition rules to a specific economic paradigm that may not be well suited for some contexts at least. And also for all the flexibility, the available intervention mechanisms require case-by-case post-contact enforcement and may not be what enforcers would actually need to take effective action. So the question then becomes how to strengthen EU antitrust law's resilience. And again, this is a complicated question. There is no simple or single answer in terms of how to do that. I think on the substantive law front, it would help to have more structure, legal tests, to use the concept used by Professor Pablo Ibanez Colombo, but also more appropriate proxies, premises, presumptions, in order to strengthen legal certainty and administrability, and also to allow for the integration of more forward-looking and systemic consideration within the assessment. I think also, to the extent possible, we should try to use legal concepts and tests that are not exclusively tied to any given economic paradigm, to minimize the risk of incoherence. And on the procedural law front, I think, yes, we can make tweaks in the existing procedural framework, strengthen aspects of the Commission's powers and so on, but ultimately, still we won't have what we need in certain situations at least. And I think what we would need is quite possibly a market investigation power along the lines of the new competition tool that the Commission proposed back in 2020 to deal with those cases where case-by-case post-conduct enforcement just cannot be effective. Just to end, I think we also need to remember EU antitrust law cannot do it all. It's just one tool that we have among many others. And I think we need to make effective use of all the tools. Major regulation is an obvious one. The DMA is another, but also beyond the competition law toolkit. If we think about consumer protection, the GDPR, Data Act, and so on, there are many different tools that can help address some of the problems or aspects of those problems. And inevitably, what this means is we will need to have more interinstitutional cooperation. So different authorities, competition and non-competition, in EU national, working together and talking to each other in order to coordinate enforcement. So what we are seeing in response to uncertainty and complexity, I think we're also seeing the emergence of an ever more complex regulatory and institutional framework. But I think still, when we think about the resilience of EU antitrust law, this can help us, because the law will continue to, the law and the world will continue to change, oftentimes in ways that may not be predictable. And I think it's important to have this framework in mind to help us cope with future developments. So I'm going to stop here, and thank you so much for your attention.